And so, did everybody receive factors 1, 3, 5, and 7? I know mine was sent just towards the end of this afternoon, maybe 20 minutes before the meeting started. So I understand if you've not had the opportunity to review that. Kristen would have sent them all around. And
I also just sent this factor 6 draft a minute ago. Well.
okay, great. Thank you. Thank you, Kristen.
Karen, I'm not sure if I've received your section. You said it was sent this afternoon for section 1?
It would have been sent around 3:15.
Okay, let me look. Thank you. Yes, just saw it. Sorry about that.
Not a problem. I sent it towards the start of the meeting, so completely understand. And not sure who did factor 6, but thank you. And I have not circulated factor 2 yet, which I also took responsibility for. What I intend to do is to take the information from the 2021 report and just bring it forward to today. And so rely largely on their information and then bring it forward from there. For those of you who just joined, there were a couple of factors sent around, factor 1 and factor 6, shortly before the start of the meeting, or at the start of the meeting. And so you should have those in your inboxes. You want to, Dan, do you want to start off with your, I believe you were factor 3, and just quickly walk us through that, and then we can ask questions?
Sure. Let me just, let me just grab it. Hold on a second. Okay, so this was fairly straightforward. We didn't have an enormous amount of information in all this. And so all I did was basically take the information that was from the gentleman who was from the National Center for State Courts, who obviously is very knowledgeable and provided terrific information, and just summarized how our rankings have at least improved modestly from 2021, from 40th to 37th. and then provided some cost of living adjustment specific information from that same source. And then also talked about the rankings of, I guess, we're doing better as it relates to appellate judges and the Supreme Court on an unadjusted basis. Presumably those rankings would drop lower if it was done on an actual cost of living adjusted basis. And then the last piece of information is something that I found, which is duplicative of the same information that was provided in 2021 on the current salaries of federal court judges. I think the charge talks about getting federal government comparable information. It doesn't seem we have any access to information beyond just federal judges, as opposed to lawyers within the federal government. And obviously there are probably hundreds of thousands of lawyers in the federal government overall, so we didn't have any data on that information. And so that's what I summarized.
Thank you very much. The Chief Justice in his report, I believe that's where I read it, also included what other attorneys are making in public service in Connecticut. Do we think that that's relevant and should be included?
I think that's definitely relevant, but I don't know that that would fall within charge 3, right?
Yeah, Karen, it's Karen Noble. And I believe that probably falls under factor 4, which I apologize. I don't think I realized we were submitting today. And I was going to submit for our next meeting. But that was going to be my area, and I was going to cover the salaries of other attorneys in Connecticut, including those in public service. That's okay.
You're absolutely right, and sorry, Attorney Papermaster.
All good. Can I just ask a question? Have we heard from anybody who thought that salary should stay constant? I don't think we have, right? And are we working off the assumption that nobody thinks that that's the case, right?
I think that's correct.
Okay.
I think that's correct. Perry, do you want to walk through your summary of 7? And a couple of points that are open for discussion? Okay. I don't know if Perry is unable to respond at this point. He's on the phone. So I'll talk about factor. What's the other factor? Oh,
Hey, can you hear me now? Sorry, this is Perry. I was muted. I apologize.
That's all right. Yes, we can hear you now, Perry.
Okay, I'm driving. I'm going to try to multitask and stay on the road here.
Please be careful.
So this is factors. Well, traffic's moving about 2 miles an hour, so it's the risk is not particularly high. The factor 7 is the state's ability to afford. So this one I think is really has to reflect the condition of the general fund as it's currently is and as it's anticipated to be. So it relies on OFA, and then I looked at some information from the comptroller on the present state. The comptroller doesn't do out-year projections, but I looked at sort of his latest report. I think it's December 2nd to the governor on the present state of the general fund. So Judicial did not give us gave us the 1-year increase for proposed increase for Superior Court judges, and then didn't give us percentages, and then said, but just said similar percentages should apply to the other offices subject to our recommendations, and then said there ought to be a CPU additional 2% in each of the years. So I had to do a little math here on what the percentages would be, and then what the total cost assuming there's some assumptions. So it assumes the same number of filled judicial positions. It assumes the same CPU of 2% and applies that out. I would really love it if we could have OFA, which I think offered to do some calculations for us on the cost. If we could have OFA sort of look at these numbers. I am not super confident in my math ability, and also maybe I don't know. I mean, I just posed whether we ought to have, because we're kind of filling in the Chief Justice's recommendation, whether we want to ask Melissa Farley to just look at this just for purposes of, do they agree with our math percentage-wise and dollar-wise and our assumptions? And so you can see that, it's not, these aren't small increases. So the first year I calculated as I think a 9.4% increase. And then I calculated what the additional increase would be. I think it would total like a 4.6% increase over the increased previous year, if that makes sense. And then I conclude that, based on, I think this tracks our conversation, based on what we know now, which is all we can know, and what we have to rely on, based on the condition of the general fund as it is now and anticipated to be, that this is affordable. I included a paragraph that acknowledges some uncertainties, but just says that uncertainties will always exist, and our charge is to look at what is known, and based on what is known, it appears that these increases are affordable.
Any questions or comments for either Attorney Papermaster or Harry at this point? Excuse me, Attorney Grossman.
Oh, and by the way, Karen, I did see Dan had some good edits, which I thought should be incorporated.
And if anybody has any concerns about the edits, that would be helpful as well. Any questions, concerns?
I missed Dan's edits. Maybe someone could flip those again to me. I'm sorry, I've been in that position for most of the day.
Not a
Read
problem.
over the others. I just read over yours.
If I can find that.
They were good, but not particularly. They didn't go to the substance of the recommendations.
I agree with the substance of the report. It's well done. Both sections.
I will certainly send those around. I'm not finding them right now, but we'll do.
Second paragraph, sorry, Karen, second paragraph in the second to last sentence added an S on the word increases and the word respectively after the 27, 29. Oh, that's wrong. That should be 28. 29 would be 4.6% respectively. He added that word, which I think is good at.
Thank you.
So I guess so the summary in terms of what the cost would be and its affordability, we're all in agreement. If just looking at the Chief Justice's recommendations without getting into what the Commission's recommendations are, we can closely mirror the Chief Justice's. Any questions about, if you have an opportunity to look at mine, is I utilize the same sources that Attorney Rothman did in terms of talking about the state's fiscal climate and pulling from the comptroller's letter, things that indicate why we think that the economy in Connecticut is strong. I did see an article in the last day or two was quoting the secretary that this current fiscal year is going to be tight. Meaning the first year of the biennial budget will be tight because of the spending cap and volatility cap. But that in 27, it will be much better. I don't know that that's necessarily something to rely on. I'm looking to see whether or not there was a formal presentation that he said that in, that I can cite to for the out years, because it looks like, based on what Robert Wysock provided to us, that the out years, based on however the cap is calculated, there was significantly higher revenue going after fiscal year 26.
I saw where OPM also has, I'm sure it's all posturing for the budget negotiations, but they directed the various agencies not to fill any open vacancies
Yes.
till further notice.
I'd also heard at one point that they've stopped automatic refill as well, which is
Hey, what?
automatic, what they call automatic refill, meaning you don't need to get budget and DAS approval for certain positions because they're hard to recruit for and are critical. So those are pre-approved, if you will. And I also heard that they were pulling back on that stuff. So. So going back to factor one, is there anything else that you think we should add into this? There's information in the back of the comptroller's letter, which talks about the national economy. It talks about the stock market. There are, the stock market has gone, has been significantly high in the last couple of years. Most of Connecticut's revenue comes from capital gains, or at least in the last part of its fiscal year. So April is always the month to watch, but we're going to have to submit this before April. But is there any other information you think we should include in that, which talks to Connecticut's overall economic climate? Factor 6. You want to walk us through factor 6?
Yeah, hi everyone. I did factor 6, and that one is the compensation adjustments applicable to state employees during the applicable fiscal year. And the first place I looked for this was the commission's report from last year, and that report included a really thorough history of the various changes, compensation adjustments for the judicial and also for state employees. And for me, it was very helpful, and I thought it was helpful to carry it over into our report. If you all disagree, we can delete all of that information, but I thought the context was really helpful to understand what has been happening over the past decade as to compensation adjustments and why or why not. So I included those in this report. And again, if you all want to take that out, we can. And then the other basis of information that I included was the information from Chief Justice Mullen's presentation. He focused and provided some information about the adjustments and increases for fiscal years 22, 23, 24, and 25 for both judicial and state employees. So I added those in as well. So those were the main areas that are in the current draft of the memo. I didn't use any other sources, but if there are other sources that you all think that I need to look at, I will do that. I just couldn't think of anywhere else to get that information.
Thank you. Any questions for Kendall Ogilvie? So we have remaining on the table factors 2 and 4, and we'll circulate those as soon as possible. I'm happy to, as Attorney Rothorn requested, reach out to OFA and ask them to provide us some fiscal backup to double check ourselves, and also Attorney Farley from the judicial branch as well. Any other, from what you've seen so far, any other information you think needs to be provided in these 4 factors?
Karen, would you like for me to walk through factor 5?
I'm sorry, I missed that. I apologize, Dean Nelson.
No, no problem at all. Happy to walk through, and I have a question that I could use some assistance with that you all may have seen it in the comment. But again, kind of looking at factor 5, the state's interest in attracting highly qualified and experienced attorneys to serve in judicial capacities. Again, provided some context from the previous report about the importance of this factor, and also kind of the mechanisms by which judges are appointed and confirmed, and then going into the testimony that we received. So relying on the Judicial Selection Commission's annual report of the number of lawyers who currently have applications approved by the commission, and that's total at all levels. That's how we get to that 309 number. And the fact that none have asked to withdraw, and then getting into the testimony from the chair person, Attorney Dolphin from the Judicial Selection Commission, expressing their concerns about the judicial compensation impeding the goal of attracting diverse qualified candidates. That testimony was also buttressed by Attorney Thompson's testimony on behalf of the George W. Crawford Black Bar Association, looking at judicial salary as a deterrent for attorneys from underrepresented communities. And then going into the retention issue, I did note that the factor itself doesn't list retention, but in previous reports and in our conversations and in the testimony presented to us, there were references with regards to retention of judges. So talked about the concerns there. And then I included the statistics from Chief Justice Mullins' report to us, as well as the answer provided by the judicial branch with regards to the attrition issues and the number of judges. I tried to keep it very factual without drawing conclusions that, that may be my own or the commission's. I'm happy if the commission would like to draw a conclusion and include that, but I really just tried to keep it very matter of fact and just presenting the evidence that was presented to us. But one of the questions that I did have, and I was looking back at my notes and wasn't sure, so I wanted to ask the commission with regards to that final sentence on the first page of my draft. Other witnesses also noted this occurrence in their testimony. So was wanting to see if Attorney Sterling also mentioned the retention issue in terms of experienced judges leaving the bench to enter private practice and earn higher salaries. I believe that from looking back at my notes, Attorney Sheeran specifically talked about that, and I just wasn't sure about Attorney Sterling. And so I welcome the commission's recollection on that, because I want to make sure that I'm accurately reflecting everyone's testimony.
I did check my notes, Dean Nelson, upon seeing your note. I didn't, if she mentioned it, I did not capture it in my notes. My notes more reflect her opinion that the Chief Justice's recommendations were moderate, and her consideration of cost of living in Connecticut. But if she did mention the retention issue, I did not capture it. I don't know if anybody else did.
Okay.
I just had a question, Dean. The footnote referencing the number of judges that separated from the judicial branch over the various years, does that include people who retired, or is that only judges that left to pursue another legal career?
No, I think the statistics that we have, just simply exactly as stated here, just judges who separated, and I don't think that we were provided the reason for the separation.
Thank you.
Yes, I know I went through the list that Melissa sent around, and off the top of my head, from my serving in my previous role, I don't know that I could capture all of the retirements, but there were a number of retirements on there for the 73.
And again, if I should include any clarifications, because I don't want to be drawing any references or conclusions or making people draw that. And again, I can include in a footnote, perhaps, again, that this is just separations without the reasons. But that was the information that was provided to us.
But it list that Melissa sent around, excuse me, Kim Farley sent around, it did indicate a similar period of time, 43 and 23. So it's definitely increased, whether it's retirements or
Dean Nelson, I took a look at my notes regarding Attorney Sterling's testimony, and she did talk about how retaining judges is important because younger judges learn from senior judges, and so everybody benefits by retaining senior judges.
Okay.
Since we have time, I think we should be able to get the number of judges who have retired versus left for some other reason. Our report's not due for 2 or 3 weeks. So I think that we can ask Melissa to see if she can at least give us get an estimate for us, because it's pretty easy for them to know who retired once they look at the records.
We can do that. And it also might be interesting. I know there was a mention of prior to this most recent cohort of departures, many or more judges took senior status, which means they stay in the system and maybe perhaps, play that mentor role for younger judges. And so that may be also where we're looking at the retention as well. Not, again, not specifically because those are retired judges, but they certainly are a resource to the bench.
Okay. So I will, make some edits to reflect Attorney Sterling's, to make sure the footnote that's associated with her is associated with the body of the text accurately. And then Karen or who would like to reach out to the judicial branch for a follow-up, I'm happy to do so, but I'm not sure that process.
I can reach out to Melissa.
Okay.
Attorney Ogilvy?
I can reach out to her.
Great. Thank you so much. I'm happy to make those edits.
Attorney Nelson, if it helps also, or Dean Nelson, if it helps also, my notes also indicate that Attorney Coffin from the Connecticut Defense Lawyers Association also mentioned how it's important to retain senior judges because of their experience. So I suppose the same
Okay.
footnote.
Thank you. I'll add that. Anything else? Great. Thank you so much.
So I started to say I'm happy to compile the factors that we've gotten so far and start the summary and outline for that part. One of the things that I think is still outstanding that the commission needs to discuss is, are we recommending the Chief Justice's proposal without any changes? And so I'd like to open the floor for that discussion. The gentleman from the federal, or that does the study of judges' salaries, I apologize, I don't have his name or his information up in front of me right now. did answer our question about whether or not other states use the CPIU or some other factor in setting salaries. In looking at those, it appears that each of those states, when they utilize that factor, included a cap, a not to exceed cap for the compensation in a particular year, so as to provide some level of predictability to that. So I throw that out there for consideration. If we are accepting the Chief Justice's CPIU plus 2%, should we include some form of an overall cap or a cap on the CPIU itself, since the 2% is a flat rate? Any thoughts?
Yeah, hi Karen. My apologies for being late, but I might as well jump right in. I think we should support the Chief Justice's recommendation, and I would think we should support it without reservation. The CPIU plus the 2% kind of builds in its own capping system. Our objective here, I think, is twofold. One is for us to be able to be sure that we attract and retain quality judges, and to do it at a level that the state can compensate. But I think with our first objective being number one, I think the Chief Justice's recommendation is one that we should endorse, and particularly in view of all the public comments that we got.
Thank you, Attorney Horowitz. Other thoughts? Attorney Shepherdson?
I would agree with that. I think they're consistent with what we've heard so far. And I mean, the two goals of attracting and retention, I think you want that built into the system. So I would endorse that.
Any further comments?
I mean, sorry, I missed the last meeting. It's when we introduced our new president at Trinity, and I needed to be there. So, what did we learn about what other units in the state do about a CPI growth factor on their salaries? A CPI plus 2% could put, if we would go through another round of inflation like we had a few years ago, it could put the state at funding 9.9% increases at a time of falling revenues. And it's not always an employer's responsibility to meet CPI.
I can tell you that based on my experience of negotiating some of those contracts in the last round, while the discussion of the inflation factor in the ground that the employees have lost is always a discussion, in terms of the base gross, what we call gross wage increase, GWI, they call it a gross wage increase. They've stopped calling it for, it's usually a negotiated rate, and doesn't track specifically to the CPIU or the CPIW. In this last round of negotiations, it was a 2.5% GWI, and then all of the contracts are slightly different with regard to what the step increases and the distance between steps, but the factor is usually about a 2% for what they call step growth. Moving along.
Yeah. I mean, this is Perry. I think we have some obligation to provide a recommendation certain as to. I think the legislature will end up having to make it. I think it's unlikely that they would just incorporate a floating CPI plus X And so I think I would be comfortable with a CPI bump +2 not to exceed
Right.
4.6. I think, I mean, we're going forward with a very large catch-up increase in the first year. And so, they may lose a little ground if inflation soars, but this exercise will repeat 4 years from now. So it wouldn't be a long-term detriment that would set, with the initial increase. I wouldn't be too worried about how far back they would be set if inflation soared.
I agree with that.
Yeah, I'd go with a cap of no more than 5. But 4.6, 4.5, 5, somewhere in there.
I would support a cap. I think it's probably just prudent to have something like that involved in this. I'll also just add, at least from my own personal experience, that working in what is characterized as big law, I'm convinced that gravity will take hold sooner rather than later, and the ridiculous hourly rates that big law is charging are going to have to stop, and the compensation will come down or at least flatten in the next couple of years. That will put less pressure on the retention issue.
I think as far as the cap goes, I don't know necessarily why we would exceed a 4.6 cap, which is what the Chief Justice is recommending, for the first year effectively.
Okay.
I think that's reasonable.
If I get I know I'm the gadfly, so I might as well continue my role. Just the point that Perry was making, that they wouldn't be too far behind because there's going to be a revisit in 4 years. That argument actually, I think, works in both directions. And so if inflation did spiral way out of control, there would be an opportunity for the legislature to make a fix. So that's just point number one. And point number two, whatever we do, you all know the legislative process much better than I do, I will confess. But whatever we do runs the risk of being compromised and whittled away. And I think that we have a responsibility as this commission, and I feel like this responsibility as a trial lawyer, that we need this. This is not optional anymore. We need large numbers of quality judges who are retained, not judges who have been associates in law firms for 6 years and decided, wouldn't this be fun? Or to have trial lawyers who people become judges who've never spent a day in court. The kind of trial lawyers, the kind of judges who say, at 4:45, put on your next witness. We need some mature people who are in there, and I worry that we are far behind. The legislature is going to be taking shots at whatever our recommendation is anyway, and I think that we should aggressively address this issue, recognizing, again, the point that Perry made, is that in 4 years, if we completely get this wrong, they'll fix it.
I am a little concerned, Attorney Horowitz, that they will, without some sort of a cap, knowing what inflation has done, knowing that they have collective bargaining agreements coming down the pike statewide, that it gives us a little less credibility with them.
I agree.
Put some cap on how much these can go up if they accept the 9.4% in the first year, which is a large jump.
Doesn't the cap set the parameters of the negotiation, though? I understand Jay in particular, who is up there quite a bit, has a good knowledge of how that the sausage is made. And but I'm concerned that no matter what we give, our credibility is important. it's going to be a negotiation anyway. So, I mean, we're sort of picking at numbers here. I think I would agree that the first year that we should be careful. Falling too far behind, I don't think that's necessarily our goal though, but it's a tricky question because it really is how do we submit a report which is helpful and relevant and honest, right? And keeping qualified people who want to be judges, keeping and attracting them. And it is, and the report that was done, the comments by, I forget who did that, I think Factor 5 kind of says it. Getting a diverse profile, all types of diversity of people, and certainly to fill the many roles of judiciary. So it's whatever we do, it's going to be a starting point as opposed to our decision. I understand your point on credit.
I'm not sure I agree with how Herb is conceptualizing our mandate here. I think it's a little bit less of an advocacy role than maybe a little bit more of an objective presentation. I think that leads us to a recommendation. I worry that I think to Karen's point, I think it will seem like we perhaps didn't do the hard work of making a choice if we just put a floating out year raise. I think that will lose credibility, and I worry that if we lose credibility on that, which I think is probably the less important than the initial, what I would call the catch-up first year raise, that we would also lose credibility on that. And then, and I also think Judicial will be in as the advocate. I think if there's an advocate here in the legislative process, it's going to be Judicial. So that, I mean, so yeah, so I think that's how I sort of see it.
I think if we're essentially supporting the Chief Justice's recommendations, we're, lending credibility towards. I think if we're an outlier and we pick a big number, they're just going to disregard it.
Any further thoughts, discussion?
Harry, would you mind just going through one more time how you get to the 4.6 as the cap as opposed to some number that's even somewhat larger than that?
I didn't understand the question, so.
I thought that you had said that there was essentially a built-in 4.6 cap to the Chief Justice's recommendation, and I'm just trying to better understand.
No. Yeah, he's not recommending a cap. I think effectively he's recommending an increase of that. I take that he's chosen plus 2% to mean he's comfortable with plus 2%. And so I'm just reacting to the one firm number he's given us, which is effectively 4.6, 2.6 plus 2%. So I think if he was very worried about inflation, well, I don't want to ascribe what may have been his thinking, but he could have picked a bigger number than plus 2% if he thought, and I think it would have been reasonable for him to think that we would be looking to try to derive a firm recommendation out of his recommendation.
So the CPIU currently is 2.6, and then with his 2, that's how you get to the 4.6.
4.6.
And would it undermine our credibility or our position if we were to at least acknowledge that there could be some moderate increase in inflation and still we think that proposal is a good one? So, for example, I know Dan, when he was first going through the numbers, said 5. Why not 5? Just because we're at 2.6 now, does that undermine our credibility if we were to pick a nice, robust round number like 5?
I'll just share my sense for what it's worth. I think this recommendation, if we go with it, even at capped at 4.6, is going to be regarded as a pretty generous recommendation.
Yes.
But I'm conscious of the fact that I think we're kind of at the outer edge of what is going to be taken very seriously.
And I'm sorry, Karen, Jay, you think that our recommendation ultimately gets taken seriously at 4.6, or is that view that both Herb and I were talking about of is we're just whether we want to be in a negotiation or not, we're in a negotiation?
I mean, just my own personal view of it is I think 4.6 is probably getting near the outer edge of what's credible.
But do you think there's some chance, I respect your opinion enormously, Jay, as you know, and that 4.6 ultimately gets recommended by the legislature? I mean, our view, we say 4.6. Are we getting whittled down to 2.6? Are we not accomplishing our objective of retaining and attracting?
It's hard to say because this is going to be in the context of an overall budget, which, has, potentially deals with salaries and benefits for other sets of employees, et cetera. So it's a much larger discussion of which we're going to be a small part. I think that going beyond what the Chief Justice recommends, I think does call into question our credibility, I think.
And you think that point is that 4.6?
Yes.
Do we have any information in terms of how the legislature reacted to the last report?
Does he cover that in his? I have to go back and look.
The statute reflects the commission recommended to increase salaries for the Superior Court judge by 4.5 in fiscal year 22. And then in the subsequent 3 fiscal years, increase salaries by the CPIU with a floor of 2.5%. And I'd have to look at what they set as a statutory salary, but I don't think they went as high as that. I could be wrong. Hang on.
Yeah, I guess the only reason I'm asking is it seems like we all been at this game for many, many years, and there's different negotiating styles that end up getting to the best place. But if we understood in terms of if we as a group, if it's likely that they would embrace what we're recommending as opposed to the advocacy purely of the Chief Justice, then it's important to put that into context for what we're recommending. But I definitely am concerned about our credibility as a group about being realistic about increases.
Yeah, somebody said it before. I think, the principal advocate for these increases is going to be the Judicial Department. Right. Our report will be, potentially an arrow in their quiver in making the various arguments that they're going to make to try and get this adopted. But they're going to be the department is going to carry the water principally. Our report will be one of several things that is considered.
Yeah, it's also going to depend a lot, as you know, about the comments I think Perry was making about the state of, the finances and what things cost and where all the demands of the budget are, as you were saying. So I don't see our role. I don't think we should be the advocate. I think the question is some of us have different views on these points, and no one wants to report to lose credibility, which I think, we want to send something up to which is at least relevant for consideration and is helpful to the goal of attracting and retaining judges. So I don't know what the magic sweet spot is, but
maybe we should consult Juan Soto.
I want his agent. Actually, the judges should get his agent. I don't want.
If I may,
Yes.
I think that us maintaining credibility is really important. But we're really almost at crisis stage in some courthouses. So there are some courthouses now where the public defender makes more than the judges are making. And so while we must maintain credibility, we have to try to, in spite of that, we still have to try to fix these imbalances, which really seem to be getting wider because we're not attracting the kind of folks we used to attract when I started in this business 20 years ago. We were getting people who were partners at big law firms who were taking the bench. And I guess we're just not able to attract them. Judicial not able to attract them now with this current compensation situation.
And I think I would just only add that, again, I think credibility is important as well. But again, I hearken back to some of the comments that we heard during testimony and some of the comments and initial impressions of members of the commission that the recommendation by Chief Justice Mullins, we kind of deemed to be reasonable, modest, conservative, even, I think, to Attorney Sterling's point. And so, of course, I realize we need to look at all of this in context. And of course, the economic viability of the state and other factors play into that. But again, I think as some would say, crisis moment that we may be in terms of judicial compensation, that coupled with, I think, in my opinion, a very reasonable and modest ask in light of the importance of the judiciary to the state and attracting and retaining the highly qualified, experienced and diverse jurists. I guess I put the credibility. If I'm ranking those priorities, I put the credibility perhaps below some of those other very important priorities when we think about this issue. But of course, I understand all sides.
Yeah, I guess I would say in response to the last couple of comments is I think we are largely endorsing, at least with respect to all of the specific recommendations by the Chief Justice, we are endorsing that. The only thing we're doing is put an outside cap on what the out year increases would be, which would be still guarantee whether it's 4.6 or 5 or whatever the number is. I think so. I don't think raising this growth restraint or putting some check on it would undermine advancing the basic recommendations of the Chief Justice or undermine the effort to try to address some of the potential, I don't know if they're existing, but potential crises with attraction and retention. So I just to clarify, I don't think we're getting far from that mission if we put a check on inflation growth.
Because the legislature put specifically the dollar amounts that the salaries would go up to each year, it looks like I just did 22 and 23. July 1, July 1, 2022 and July 1, 23, and then 23 to 24. It looks like it is approximately 3% increase for the Superior Court judges. I think the other ones.
If it helps, I'll jump in for a moment as a chief financial officer who's built many private not-for-profit and government budgets for about 33 years now. The proposed salary increase doesn't. If this hit my desk as a state employee, the proposed salary increase wouldn't bother me because it's well documented and well defined of what we need and what we need to do and why. It's that uncapped potential increases out in the future that would be a problem for me, and that I'd have to raise bells and whistles about, particularly coming out of what we've just seen in inflation. So it's that uncapped CPI plus 2% that would call the reporting into question for me. But what's coming forward for a base salary increase makes perfect sense. And yeah, we have to do this, but then don't hit me with this uncapped liability in the future, because that's coming from my part of the world. That's where you get that's where you have problems, and that's where you start to raise whistles.
What about this as a compromise? That if I understand our charge, Karen, that we come back, this commission, some form of it comes back again in 4 years.
Yes.
So suppose we were to say that inflation is running at a certain rate right now. But in the event that inflation goes berserk over the next 24 months, we would recommend an early reconvening of the Judicial Compensation Commission in order to address that threatening issue.
We could certainly recommend that. They would have to amend the statute, or notwithstand the statute and convene it. I don't think they can do it otherwise. That is certainly one of the ways to address it.
I'm sorry, Jim, but what did you suggest?
So what I was saying, Jay, was it sounds like the fear that what Herb Shepardson and I both were expressing is that inflation goes wild, and now it's the judges who take it on the chin, and that others were, like Dan and Perry were, and you, worried about our credibility if we say let's pick up a bigger number than 4 or 6. And so it was kind of a compromise on that, is keep it at the 4 or 6, but acknowledge that if inflation were to go berserk over the next 24 months, we would recommend an early reconvening of the Judicial Compensation Commission so that that issue can be timely addressed, rather than us having to suffer the loss of judges in the years 3 and 4.
Well, correct me if I'm wrong, Karen, but nothing would prevent the judicial department for coming back in the interim period and asking for a rate increase for the judges, would it?
No, not to my knowledge.
So we wouldn't be.
Can I make a different suggestion? Sorry, Jeff.
I was just going to say, we're not locked in from being able to argue any of these points again for the next 4 years.
Correct.
Just by issuing our report.
Yeah.
To back it up, other than what we're doing now. Correct.
Right.
Maybe a different suggestion is it would trouble me if the say inflation was 0.5% and it was CPI plus 2 capped at 4.6. That could be, they would get a 2.5% bump. I'm not sure that's great, right? Like I think Karen, you mentioned in a past year there may have been a floor recommended, but not a ceiling. We may want to consider recommending both. Sorry, go ahead.
I'm sorry, there was no additional 2% on that one, but yes, there was a floor, not a ceiling.
Okay. I mean, we might also want to, because state employees are going to keep getting their 3% or whatever, we may want to have, and this may make some folks on the call feel a little bit better about having a cap. We might want to recommend a floor, so it's not to, and I think they might actually might like this more. We might want to recommend a floor and a cap, and it could be, I don't know, floor at 3%, just to throw a number out.
That puts you on par with the state employees.
So Perry, if
I think, sorry, go ahead, Karen.
Are you putting a floor of 3% on the CPIU or a little?
No, so CPIU plus 2.
Got it.
But with a floor, at 3. So say CPI plus 2 turned out to be 2.2 or 2.5 if there was really low inflation a year, they're at least going to get a 3%, but they could get a 4.6.
Yes, I agree with you.
I like the idea of a floor, and that's the other end of it, and probably saves on the credibility issue. That's, I think, a reasonable compromise. I still have concerns about the inflation going crazy, as Jim has been mentioning, but I will tell you, we're trying to read tea leaves that nobody has at this point. So I think if you try to build some parameters in there, might be reasonable, because I do think the judges have been behind for a while. And I think when they see that the other state employees are getting their raises, I think it's bad. It's a bad vibe. So I like that idea.
I still think you need a floor and a cap.
I do too. Well, we're talking about that. So I said, I like that compromise aspect of it under the circumstances.
Where would you put the cap? It's 4.6?
I would.
That's what I would do, Shay.
Yeah, I would too.
I would too.
With that floor, I think it's a reasonable parameter. At least there's some, you kind of know where it's going to be within parameters. So.
Is everybody comfortable with that approach? If not the actual floor and ceiling.
Yes.
I am.
Yeah,
Yes.
With the 3,
Yep.
4.6%. Okay,
I'm sorry, Karen, can you repeat it one more time? What's the floor?
the floor of 3%, in other words, with the CPIU plus 2% cannot be less than 3%, nor exceed 4.6%. Again, take and somehow work this in, taking into account the fact that we're asking in the first year for the base salary to increase. So that would be those numbers would be for years 2, 3, and 4. Year 1, we would be asking for an increase in the base salaries. And we could write it that way and go from there. Is everybody comfortable with that?
Yep.
I am.
All right. As I said, I'll be happy to throw together the factors into a draft of the report with an intro and a recommendation, and get it to everybody early next week. When is our next meeting, Kirsten? Is it the 12th? No, today's the 12th. Apologize. No, today's the 11th.
It's the 18th, isn't it?
Thank you.
Our next meeting's the 18th.
I believe so.
You are.
Yes, 9 o'clock.
Yes, that's what I have.
Yeah, maybe out of luck for that. I'll wait and see.
At 9 o'clock?
Yeah, I may be traveling on the 18th. But I could try and call it. I don't want to screw up everybody else. Would you anticipate we'd be voting on the final recommendation at that point?
Yeah, so I will try to get the draft of the report to everybody by the 16th. We may still have to have OFA do some numbers and fix our math and have judicial looking at the same thing. So we can, if we need to just, once everybody gets a chance to look at it and we have the edits and that, we can send around a final draft and we can, and Kirsten, if you can help us figure this out, but we could probably do a very quick poll, as long as everybody is comfortable with the recommendation we're meeting, just a very quick online vote that the report is good to go and ready to be signed off.
Okay.
Absolutely.
Okay. Right. Anything else for today? Thank you all very, very much.
Thank you, Madam Chairman.
Thank you.
Thank you.
Thanks, everyone.
Hi, everyone.
Bye-bye.